All rise. The Court of Appeals Division 1 is now in session.
Thanks. Please be seated. All right, good morning. We're here for oral argument in the cases Danielle Pope versus City of Phoenix and Rachel Roberts, City of Phoenix, consolidated TX20-006 and 21-004. As you know, we record and live stream these proceedings, so please give your name and the name of your client when you're introducing yourself. We're arguing now from the podium. You'll each have 20 minutes per side. You're certainly not required to use all of your time. And if you keep in mind that we have read the briefing, studied the record, and discussed your case in conference this morning. With that, would you like to start?
Thank you, Your Honors, and may it please the Court. Robert Schaefer on behalf of plaintiffs Daniel Pope and Rachel Roberts and the putative classes. Plaintiffs are before the Court this morning because we believe the customer facility charge adopted by the City of Phoenix is really a disguised road user fee masquerading as a legitimate facility user charge. There are two facts about the customer facility charge that we believe distinguishes this case from Carball and Sabin and makes it so the holdings in those cases are not controlling in this case. And those two facts also establish why this is a covered road user fee. First, the CFC is a head tax. It's a tax directly imposed on car rental drivers. It is not an occupation tax or a TPT, transaction privilege tax, which is the kind of tax that was at issue in Carball and Sabin. Therefore, the tax in this case, because it is directly imposed on car rental customers, it makes sense to look at what they're getting for the fee that they're paying. And what the customers are getting is what they're paying for is the ability or the privilege to use a rental car on the state's highways.
Counsel, your statement that this is a tax directly imposed on the car renter, is that based on Phoenix City Code 4-79? Is that the specific?
4-79 and by implication 4-78, the related statute that discusses the customer facility charge as well.
But it's the obligation of the rental car company to pay, and if they don't collect, they're nevertheless on the hook. Is that accurate?
That's accurate, but they collect as a trustee. And that's clear from the ordinance. They hold the funds in trust. They never have legal or equitable interest in the funds, and they pass the funds along from the renter to the city. And they never have ownership.
If this were just a fee imposed on the car rental company, and it's 1% of the transaction cost, in your view, would there be a problem?
Not if it is a generally applicable tax that applies to more than just road users. If it's a targeted tax that applies only to road users, we would be arguing something different.
And why are you saying this is a prerequisite to using roads? If someone can simply go somewhere else and rent a car, it seems like they're free to use roads. They would have to Uber or take a cab, presumably, but it seems like it's more of a fee for the convenience of being able to rent at the airport, as opposed to a prerequisite.
And to piggyback on that, because you said the only thing they're paying for is the use of a rental car, but clearly there are other circumstances here where they're paying for convenience. They're paying for not having to take an Uber. They're paying for a one-stop shop. They're paying for, if my Alamo car isn't there, I can go over here to Hertz and do something without having all of that. So isn't there something more to piggyback on to Judge Catani, what they're getting in addition to using roads only?
You're correct. They are getting the convenience or the ability to get a car at the airport. But significantly, what's important is the practical effect of this ordinance. And the ordinance is based on, this is the second fact that I was going to get to earlier in my introduction, which is that the fee is based on the number of days the car is rented. But that does not correlate with any benefit or use of the facility. And so when we look at what the actual effect of this ordinance is, it charges someone who rents a car for 30 days 30 times more than someone who rents a car for 1 day. And yet they use the facility and benefit from the facility the same.
Isn't there a little bit more use if someone wants to return a car early? They're renting from someone who's at that facility. And again, if they had just charged a percentage of the sales price, which is the rental price, which is tied to how many days,
Well,
you're saying that would not be problematic, but it is problematic because they've said the number of days.
That is absolutely right, Your Honor. It's problematic because what we have to look at are the attributes, the attributes of the charge. And do the attributes of the charge in practical effect, the real world consequences, are those attributes more like a legitimate user fee, or are they more like a road user fee?
But what if they had just, if at the garage, after you've rented a car, you have to get a ticket, and then when you return to the garage, you have to pay, and they've charged, admittedly, there'd be an argument that seems odd that you're paying for how long you've been away, but we're not even involving the rental car company, but wouldn't that make it clear that this is just a facility use fee, much like parking in a garage downtown? If you want to rent it from here, as you leave, you're going to get a ticket, and when you come back, you're going to have to pay.
Yeah, but in the parking example, Your Honor, the fee or the charge corresponds with the extent of use. So you go into a parking garage, you park there for 5 days, you pay 5 days of a daily fee, $25 a day, $25 a day. The fee matches the use, it matches the benefit. Here, rental customers all pay a daily fee, but they all benefit the same from the use of the facility. Anyone who rents a car for a day can bring it back a half day early. Anybody who rents a car for 30 days can bring it back 10 days early. They all benefit the same. And so the charge does not correlate with the services or the convenience or the benefit that's either used or reasonably usable. That's the standard that the Supreme Court adopted in the U.S. Shoe versus United States case. The question in that case was whether a harbor maintenance tax that is measured by the value of the cargo is a legitimate user fee. And the court said, no, it's not a legitimate user fee because it's measured by the value of the cargo, which does not correlate with services that are either used or reasonably usable by the ships. Okay, this is the same type of situation. We have a situation where people pay a daily fee, but that fee does not correlate with the services or the benefit or the convenience that's used or reasonably usable by the renters. Now, in looking at whether this is a...
But are you saying if it were just everybody paid a $20 fee?
Correct.
You're saying you wouldn't have any issue with it? That would just be a facility fee?
Yeah, there would be no reason to question its legitimacy as a facility fee because everyone pays the same and therefore it correlates with use. And as an example, California has a statute that regulates facility charges at airports. San Francisco has a one-time fee, $14, no matter how many days you rent the car. Los Angeles is now adopting a consolidated rental center, and the statute says that if a daily fee that's equal, so $14 a day, if that doesn't raise enough money, you have to establish a factual basis, but you can use a daily fee, but it has to be capped at 5 days. And the reason why is because capping a fee at 5 days makes it correspond more to the benefit of using it, as opposed to an uncapped fee, which it more resembles a road user fee because the more you use the car, the more you have the privilege of using the car on the roads, the more you pay. And therefore, it resembles a road user fee more than it does a legitimate facility charge.
I guess I'm also hung up on the language in Saban that suggests that a user fee is something that's a prerequisite to the legal use of the roads. And that this, again, with the point that you can go somewhere else
Sure.
and rent a car.
Two responses to that. First of all, Your Honor, just because you can avoid a user fee by taking some other action doesn't mean that when you pay the user fee, or pay the fee, it's not a road user fee. Think of a toll. You can go somewhere else, not take the toll road, not pay the fee. But if you do take the toll road and pay the fee, that's a road user fee, and the money has to be spent on roads. Now, the anti-diversion provision does not say that the charge has to apply to every person who drives a car.
And on a toll road, that the money can't be used to maintain the toll road? Does it have to be used for all roads throughout the jurisdiction?
No, as long as it's used for a road or highway purpose. So it can be used on the toll road, it can be used on any other road.
But it's not, I'm envisioning the use of a toll road, you can't just say that's a use, just like using a garage. And if I'm using, I guess that's the point the city is making, that you're using the garage here. If you don't want to use the garage, go somewhere else, but it's just a use fee for using this facility, for the convenience of using this facility.
Well, again, our position is that because the fee has to be paid for using the toll road or for using this particular rental car. Now, yeah, you can avoid the fee by going somewhere else, but it's still a prerequisite for those who choose to use the toll road. In other words, just because the city could not enact a toll road and charge everybody a toll road and say, well, the money can be used for anything. It can be used for a rental car center. That money was raised from road users based on their road use. Therefore, it is a road user fee. And what we think makes Sabin and Carball different is that this case, two facts make Carball different. That case was addressing, and in particular, the Court of Appeals in Sabin was addressing whether any connection to road use. Well, that's not this case. This case is not about any connection to road use. This case is about a direct connection to road use. If you pay the fee, you get the car to use on the road. If you don't pay the fee, you don't get the car to use on the road. Sabin did not, it addressed an indirect connection, meaning is it a road user fee if it's based on use by others? In that case, the fee was imposed on the rental company. The argument was that that is an indirect connection with road use. And the court said, no, that's not enough. It has to be a direct connection. The dissent then said, yeah, but this is really targeted at road users. And the majority opinion said, no, it's not. It's part of a tax plan that deals with hotels. So it distinguished the case based on two facts. And the second fact was that it's not a targeted road user fee, whereas here we do have a targeted road user fee. Now,
but it seems like Sabin is even less sympathetic than this case, at least from the taxing authority's perspective. There, you're imposing a tax that's going to build a football stadium. It has really nothing to do with. Here, you're imposing a tax on people who are using a particular facility, and
you could impose a legitimate facility charge. We're not disputing that. What we're saying is that this is not a legitimate facility charge because it's not correlated with use. It's correlated with road use.
So if the fee was just a one-time flat fee, not based on the number of days, then it would be okay?
Yeah, our position is there would be no reason to question its legitimacy as a facility charge because it correlates with use and benefit and convenience.
And even if the rental car company simply passes along their charge to the customer and does it based on the number of days they have it, or a percentage, if they do it based on a percentage of the contract, which seems to translate to something equivalent to a daily amount, that would still be, that would be okay.
If the rental car company made the independent decision to collect the fee, it would not be a road user fee in our view because it would not be required to be passed on by the government. That's the distinction. In that case, in the Sabin case, the question whether the company would pass it on was entirely up to the rental company. Here, you can't read this city ordinance. Justice Kagan said we're all textualists now, and that's very true, but you have to look at not only what the ordinance explicitly states, but what it necessarily implies.
It just seems to me it's a little bit counterintuitive to suggest that a rental company would do anything other than pass along a charge. None of these companies are charitable organizations. They're presumably, that's what happens if you impose a tax. It doesn't seem like there's that much difference in saying.
pardon me for interrupting, but that gets into some really complicated economics, Your Honor, which is can they pass the charge along given that we now have major competition to rental cars? I mean, if you try to jack the price up too much, more people are just going to take Uber.
Yeah, but why can't the same be said of the rental car company is now going to have to lower their price on this one because they have to collect this amount and forward it pay it to the government. So that means they're going to have to lower their rates. They're going to make less money on this one. That
may be what they have to do, Your Honor, but the question is, what does this statute require the company to do? It does not give these companies the option of lowering their rate and absorbing the fee. It says shall collect. And in Garrett, the court said the key consideration in legal incidents is whether the government intends for the business to pass the burden of the tax along. Shall collect is the critical language. It's almost magical language that makes this a collection agent. Other aspects of the ordinance do the same thing. In Section 478D, Section 878D imposes a concession fee, and it requires that the off-site companies acknowledge that the concession fee is for the company's use of the airport. The companies also pay rent. If you look at the lease, which was attached to our response to the motion to dismiss in the Roberts case, the lease requires the companies to acknowledge that the rental payments and the concession fees are for the company's use of the airport facilities. The customer facility charge must be for something else, and it's for.
Are they necessarily mutually exclusive? Can't you say you're going to pay rent and you're also going to pay? You could have imposed, again, if you impose it directly on the rental car company, the fact that you're paying rent doesn't mean you can't also do something else based on the amount of use.
Absolutely. The city could have structured this differently, and we would not be here. If the city had simply increased the rent to the rental companies in order to pay for the part of the SkyTrain and pay for the rental center, that would be a different situation, because then it wouldn't be the government coercing the customer to pay the fee. It would be an independent decision of the rental companies to pass that along. And so there wouldn't be causation between the fee and the payment. Here, there is direct causation between the imposition of the fee and the requirement that the burden of the fee be passed along to the customer. And on the issue of prerequisite as well, Arizona also has other charges that are like a motor carrier fee, a light vehicle use fee. None of those fees, I mean, it's still legal to drive if you don't pay those fees, but they're still road user fees. Just because there's a statute that says you can't drive unless you register your car, or you can't drive unless you pay a license, unless you get a license. Those, yes, they do say it's not lawful to drive unless you pay those things, but here it's also not. It doesn't even make sense to ask the question whether it's lawful to drive if you don't pay the CFC, because you're not going to be able to drive.
But it seems very different, because in that situation, you can't do anything that would make it legal for you to drive. Whereas here, you just go rent a car somewhere else, and there's nothing illegal about driving a car rented from somewhere else.
It can't be voluntary in the sense that you can simply go somewhere else to avoid it, because this is an instrumentality of interstate commerce. Rental cars are instrumentalities of interstate commerce. The government is putting a tax on the use of an instrument of interstate commerce. And can the government just tax that and say, yeah, but you could fly into the Kingman Airport if you don't want to pay this fee?
Can you, before you sit down, can you just talk a little bit about standing and remedy? Because I'm sure that's something that we're going to hear from the other side.
Sure. On standing, we believe standing is established by the fact that the legal incidence is on the customer, that it says shall collect, that it says that the rental companies hold these funds in trust.
But who would they go after if they weren't getting the money that they thought they were due?
That question doesn't even arise, because you don't rent them a car unless they pay the fee. This isn't a situation like cigarette taxes, where you might not be able to collect the tax immediately upon payment, and so you have to have some mechanism to go collect it later. And this specific issue, Your Honors, was addressed in the Colorado National Bank case, which was a case that Judge Ginsburg referred to in the majority opinion in a 1995 case, U.S. versus Williams. And in that case, what the court said was, listen, a trust fund tax by definition is imposed on the party that the charge is collected from, not the party that collects it and passes it along. And that's the same legal incidence standard that was adopted by many other Supreme Court cases. The Ninth Circuit in the Board of Equalization case recognized the same thing, that the legal instance of a tax is on the party that pays the tax, is required by the government to pay the tax, not the company that collects it as a trustee and merely passes it along. On the question of remedy, we don't think the issue of remedy is before the court. The only question is whether we have standing to seek a refund and standing to seek injunctive relief. And we believe we do have standing to seek both a refund and injunctive relief, and there really is no argument against that, other than that the anti-diversion provision really just restricts spending and not taxation, and we've addressed that argument in the briefs. Thank you, Your Honors.
Thank you.
Good morning, Your Honors. May it please the court. My name is Eric Frazier. I represent the city of Phoenix. You are not writing on a blank slate here. The Supreme Court issued a remarkably specific holding. A fee violates the anti-diversion provision only if it is a prerequisite to or triggered by the legal operation or use of a vehicle on a public road. This provision does not require that the fee be proportional to the benefit. This is not an equal protection case. This is not a roving license to assess the policy of the airport fees. They say that if you pay the fee, you get to use the car on the road, and that's why this triggers Article 9, Section 14. But that's true with the tax on the sale of a car, with the tax on a lease, a 2-year lease of a Toyota. The Supreme Court was really, really concerned here about the dangers of interpreting this provision, this constitutional provision, too broadly. That's why this Supreme Court, which is unabashedly textualist, did not stop with the text. The phrase relating to is almost impossible to pin down. And so the court announced a very clear holding, prerequisite to or triggered by the legal operation or use of a vehicle. So really what the Supreme Court is asking is this: if you don't pay the fee, can you legally drive? It's not about can you actually escape paying the fee? Can you get out of the turnstile at the rental car center without having paid the fee? The question is, if you don't pay the fee for whatever reason, are you allowed to drive on the roads, or are you breaking the law? So even if we take the plaintiff's interpretation of the city code, even if we assume that this is a direct tax on the renters rather than the rental car companies, even if we assume that the legal incidence is on the customer, and even if we assume that the thing that triggers this fee is renting a car rather than using the facilities, even if we assume all that, this still passes the Supreme Court's test, because you can still legally drive.
How about if they were to impose an extra, the city were to decide, we're going to impose another 10-cent per gallon tax on gasoline? Would that violate the anti-diversion provision?
Yeah, so the gasoline tax is under a separate part of Article 9, Section 14. I think that probably would violate the provision, only if you spent it on non-roadway uses. Of course, you could spend it on roadways, that's fine. But if you spent it on non-roadway uses, that might violate the Constitution. But the prohibition on using monies from gas taxes is worded differently. It doesn't have the same kind of language here, because the Supreme Court really said, if you give this expansive view of relating to the operation or use of a vehicle, you render that gas tax issue surplusage in the Constitution. So that the Supreme Court looked at that and said, that must mean that the voters did not intend to apply Article 9, Section 14 to things that you do before you drive a car. That's why the court says, no, this does not cover taxes on tires. It does not cover taxes on the sale of a vehicle. It does not cover taxes on the lease of a vehicle. You've really got to have some kind of a limiting principle that carves out a 2-year lease on a Toyota. Otherwise, we're just going to do crazy things to the taxing structure in Arizona. And the Supreme Court said, we're not going there.
But I think here they're suggesting it's because you've specified it's a tax based on the number of days you drive that seems to correlate to road usage.
But correlation is not part of the Supreme Court's test. The test is it a prerequisite to legally driving on the road? And so, I want to maybe focus this by thinking about a fee that everybody agrees would not be covered, which is the fee you pay to park your car at Terminal 4 at the airport. If you leave Terminal 4 and you don't pay your fee, right, maybe the car ahead of you goes through and you slip through before the big arm comes down, if you don't pay your fee, you have broken the law. And you owe a debt at that moment to the city of Phoenix. But you are still allowed to drive on the road. The fact that you owe a debt, the fact that you broke the law and did not pay the government-imposed parking fee does not affect your ability to drive on the road. You are still a legal driver. By contrast, the fees that do fall within Article 9, Section 14 and do go to the State Highway Fund are completely different. There are statutes that say if you don't pay your registration fee, you cannot legally drive. If you don't pay your license fee, you cannot legally drive. And a police officer can pull you over because you're driving. Here, with the parking garage fee or this facility fee, a police officer could not pull you over because you're driving. It's not the driving that is illegal. It's just the fact that you skipped out on a government-imposed fee. That's why the one type of fee has to go to the highway fund, and this other whole category of fees does not have to go to the highway fund. It is not a legal prerequisite to driving a car.
So I'm just pre-associating here, but if the city were to build a bridge across the Salt River, is it okay to charge a toll just to use that bridge to cross the river? Can they use that money on the bridge itself and not for other general road use?
Yes, absolutely. So
I guess their argument would be, well, that's still a road use compared to a building. So sorry, bad question.
No, I think that's a good question, right? Which is the central harm here is diversion. The central evil that this provision is designed to address is taking money from one purpose and spending it on another purpose. It turns out all of these anti-diversion provisions originate with the federal government. The federal government does not want to give a state or an airport or a local jurisdiction money and then have them take related money and spend it somewhere else. So we passed Article 9, Section 14, as you know, because of the Hayden-Cartwright Amendment, which is not even in effect anymore. But that was because the federal government said, we will not give you road dollars if you divert road user money to something else. The federal government has also said, we won't give you airport dollars if you take airport money and spend it on something else. The central evil is diversion, but there's nothing wrong with what's happening here because this is the airport needed a rental car center. And it is paying for that rental car center through fees assessed at the rental car center.
What's a little bit counterintuitive is the fees are based on time that you're spending away from the center, as opposed to just, we're just going to charge you a $25 fee for renting here at the center. And when instead you do it based on how many days are you going to be away from the center, that's where it looks more like a tax on something other than a convenience fee for using the facility.
So there's a difference between what triggers the fee versus how that fee is calculated, metered, computed. And what triggers the fee, in our view, is using the rental car center. Even under the plaintiff's view, what triggers the fee is renting a car, which is just a business transaction. Even renting a car, if we assume their view that that's what triggers this fee, that's a business transaction. It's not using the roads. So the Court of Appeals in Sabin, before it went up to the Supreme Court, completely said, essentially, if this is a tax that is triggered by renting a car, that is not the same thing as using or operating the car. That is a tax on a business transaction. So here, this fee, even under the plaintiff's view, is a fee on a business transaction. The Constitution does not prohibit things that correlate roughly with road use, because the Supreme Court said we're not bringing taxes on tires into the scope of Article 9, Section 14. And guess what? If you drive more, you need more tires. If you drive more, you need more motor oil. But those fees and taxes do not go to the highway fund. And the plaintiffs conceded during their argument that your example of a percentage-based fee would be okay. But that doesn't correlate with use of the rental car center any more than the daily fee does. Because somebody who rents a Lamborghini for a month would pay a much higher fee than somebody who rents a Toyota for a day. The Article 9, Section 14 is not an equal protection clause. It is not a roving license to assess the public policy rationales for how the airport funds its facilities. It is a narrow provision that the Supreme Court has now articulated, and it means a prerequisite to or triggered by the legal operation or use of a vehicle on a public road. That's it.
So in your view, it makes no difference that the rental car company is obligated to pay. You would reach the same result if this were a tax on the driver or whoever rented the car, and they were obligated to send in the tax directly to the city.
So I think it makes it an easier case if the legal incidence is on the company, but even if the legal incidence is on the customer, all the arguments that I've been making today would still work. You know, in our papers, of course, we made arguments covering both scenarios. If the legal incidence is on the rental car company, it's easier. We also argued that the legal incidence is on the customer. It still passes the Supreme Court's test. Everything I've told you orally here today applies under the plaintiff's view, where this is a fee charged directly on the customer. Because even if the customer doesn't pay, even if we assume that they have the legal obligation to pay, you can still drive on the road legally. You're not breaking any law when you drive. And the Supreme Court has already rejected this armchair analysis that you rent a car to drive it. Of course you rent a car to drive it. You also, when you buy a car, you also intend to drive it. When you lease a car for 2 years, you intend to drive the car. But the Supreme Court said taxes on sales of cars, taxes on 2-year leases don't fall within this provision, because the triggering event there is the business transaction. It's buying the car. It's leasing the car. It's not driving the car. It's not operating or using the car. You can operate or use the car without having paid that tax. So if you go to a shady car dealer that doesn't collect the tax and they're breaking the law, you owe the government money. The Department of Revenue will probably come down on you very hard for not having paid that tax. But you can still drive on the roads, and driving on the road is not illegal. Driving on the road is illegal if you don't pay your registration or your license. Those are the fees that fall within the constitutional provision. I'd like to address standing briefly, because again, even if the legal incidence falls directly on the customer, there is still no standing. The plaintiffs brushed off this question about the remedy as not a standing question, but redressability absolutely is a part of the standing inquiry. That's what protects against issuing advisory opinions. If the court cannot remedy their harm, there's no redressability, then the court is just issuing an advisory opinion. I think it's really important to look again at the constitutional provision and what it prohibits. It does not prohibit assessing fees or taxes on registration or license or operation or use. You can do that all day long. That's why we have a registration fee. That's why we have a license fee. We are allowed to assess those fees. This is an earmark. And so the prohibited act is diversion. The prohibited act is spending the fee on something else. The Constitution says no money is derived from. That is how the Constitution starts. No money is derived from. And then it talks about the fees and taxes that are covered. Then it says, this is a quote, shall be expended for other than highway and street purposes. That is the prohibited act. The prohibited act is not collecting the fee. It is not imposing the fee. It is spending the money. But what interests do these particular plaintiffs have in how the city of Phoenix spends its money? And refunds are they're just not available in these types of cases where the fee or the tax is constitutional and it's the spending that's the problem. There are 2 cases in the country that have really addressed the remedies in anti-diversion provisions. The Beaver excavating case from Ohio, and then there's a case from Michigan. Neither of those cases ordered refunds. Neither of those cases enjoined collection of this fee, these types of fees and taxes. The courts there said, we can't enjoin collection of the fees because collecting the fees and collecting the taxes is constitutional. All they did, they said the most we can do is a prospective injunctive remedy prohibiting spending until the government comes back in and spends the money in the right way. But these plaintiffs have not even requested an injunction of any kind. The only thing they've requested is refunds, which are not available, and declaratory relief. And again, the Michigan case said that declaratory relief of this kind is not available because these fees are constitutional.
So you're saying the only one who can attack this or challenge the fee would be the rental car company? They could, but then the city has made them sign something saying they won't sue in exchange for being able to use a facility. So that means no one can ever raise the challenge if there were a legitimate anti-diversion claim?
So first of all, I don't think contractual waivers or contractual releases affect the standing inquiry. Otherwise, you'd have all sorts of problems with contractual releases. But I think under our view, again, where this is a charge imposed on the companies, a rental car company would have standing to sue. Presumably, they would have to allege that they have a continuing interest in how Phoenix spends the money and the condition of the roadways in Arizona. I think they would have to allege more than just that they paid this fee. And even if you take the plaintiff's view that this is a charge on the customers, I think there it would have to be a Phoenix resident or somebody who can articulate a legitimate interest they have, not in the fee, but in the expenditure. They would have to articulate that they have a continuing, prospective, future interest in how Phoenix spends its money or on the conditions of the roadways. So maybe they could satisfy that by claiming that they come here every month, that they're snowbirds and they have a winter home here. Maybe they could satisfy that burden by saying we plan to visit frequently in the future and we have a strong interest in how the roadways are maintained. But there are no allegations like that here. And again, they have not requested that kind of prospective injunction. So even if they had alleged those facts, they have not requested a prospective injunction because they don't care. It's clear they don't care. It's clear that they want refunds, but that remedy is not available in the anti-diversion cases. Before I sit down, again, closing on the merits, Sabin is the elephant in the room here, and it is unusual for our Supreme Court to articulate a test that is this specific. And they did it twice in the opinion. The Court of Appeals articulated the same test. The Supreme Court said, we agree. They said it twice. The test is a prerequisite to or triggered by the legal operation or use of a vehicle on a public road. It is not about correlation. It is not about whether this is a good fee, whether the customers get any benefit from using the airport. This is not a question about whether a judge would impose this fee if they were the manager of the airport. This is about whether the fee is constitutional. And the Supreme Court rejected the arguments that the plaintiffs are making now. This notion that it's a targeted tax, it's a special tax, the Supreme Court rejected that. And that's where they're pulling these words from about whether this is a fee that's limited to one kind or whether it's part of a general taxing regime. That, if you look at where that comes from the opinion, that is when the Supreme Court is rejecting the same argument that's being advanced here. If there are no further questions, I will forfeit the rest of my time. Thank you.
Thank you, Mr. Frazier.
I have very little time left, but let me try to
Very
make
little.
3 quick points. The first, it says that if you don't pay this fee, you can still drive on the roads, and therefore it's not a prerequisite. The exact same thing is true for motor carrier fees. If you don't pay the fee, you can still pick up passengers, take them somewhere else. You owe the fee, but you can still legally drive, yet it's still a road user fee. On standing, they say that there's no redressability. And the Beaver case dealt with requiring prospective relief. We have sought prospective relief, but the bigger point is that in those cases, it was not a tax that was imposed for a particular purpose that was not lawful. If the federal government or anybody else put a tax on all of us to pay for religion, the Establishment Clause prohibits expenditures to establish religion. You could still challenge the validity of the tax because the money is being spent for an improper purpose. The diversion makes the collection illegal. Thank you.
Okay, thank you. All right, thank you for your arguments. We'll take the matter under advisement and issue our decision in due course. We'll stand in recess to reset for our next argument. Thanks.